All right, we can go off the record. Here's the thing. She doesn't want you anymore. That relationship is over. She's not your wife anymore. She does not want to be with you. Do you understand?
I want the truth. You can't handle the truth.
Hello, Judge Boyd.
Hello.
How are you today, ma'am?
Oh, I'm doing great. It's a beautiful Friday. According to you entered a plea to kidnapping of no contest on March 20th, 2023. According to the plea, punishment is to be assessed at 10 years in the prison. The state opposes your application. They're taking several cases into consideration. There's an affirmative finding of family violence. Are there witnesses?
Yes, Your Honor.
Oh, you want to call her?
I thought it was for victim impact statement after sentencing.
We will be calling her as a witness, Your Honor.
All right. Call your witness.
Ms. Tovar, you are the victim in this case against Mr. Zaragoza.
Yes, sir.
And you are aware that he has applied for deferred adjudication with probation.
I am.
And what are your feelings if the defendant were to be granted probation?
Objection, Your Honor.
And what's your objections?
He's telling you what effect your decision will have on her. And we don't want her influencing.
All right, that'll be sustained.
Do you want the defendant to be released on probation?
Objection, Your Honor. It's the same thing.
Sustained.
I'll ask the court to disregard, of course.
Oh, yes. It's disregarded.
Ms. Tovar, on December 21st of 2021, can you tell the court what happened?
So I visited Ray to pick up Christmas money because me and the kids were living in Atascosa County due to CPS case that we had for domestic violence.
Your Honor, I object because it's repetitive. Everything about that offense is in the police report, which was presented to the court as part of our plea package.
All right. So just so all parties are aware, I've read the stipulations in its entirety. I always reread those before sentencing, and I read them once I make a decision on whether there's sufficient evidence to find somebody guilty. And I've also thoroughly read the TAP evaluation. So you can ask your next question.
Yes. Ms. Tovar, have you had any contact with the defendant since these allegations?
Yeah, so he calls the house and speaks to myself and the kids. I guess when he can, because he doesn't have any reason.
Objection, non-responsive. She answered his question.
All right, that'll be overruled.
You can continue.
Oh, so he has to use, I guess, a pre-collect call that he has because he doesn't have any money on the account to call us.
Okay.
So, and I don't fund it anymore. I just did for a little while around Christmas time, but no, it's only when he gets a collect call he can call.
And Ms. Tovar, you currently have a protective order against the defendant?
I do.
And do you feel that is sufficient to keep you safe?
No.
And why is that?
Objection, Your Honor.
What is your objection?
She's commenting on what your decision will ultimately do to affect her and her children.
All right, that'll be overruled. You can answer the question.
No, I don't think so. It didn't in the first place. It didn't. Ray was still coming around and still calling.
And while these cases were pending, you did have a no contact order against the defendant, correct?
Right. But I was told that to let him talk to the kids. So even though we have a no contact order, and that's why I was taking calls so that he could talk to the kids. I didn't want anybody to say that I wasn't allowing it. Yeah, because they're not part of the protective order. It's just me.
Thank you. Nothing further on.
All right, defense.
No question.
All right, thank you. State, do you have another witness?
No other witnesses. Your Honor.
Defense.
It's the defendant himself.
All right, if you come forward, could you raise your right hand for me, please? You can lower your hand, state your name for the record.
My name is Zaragoza Ray, the Water Jr.
All right, defense.
Thank you. Mr. Tovar, did you want to address the court with regard to why are you requesting her to give you probation?
Yes, I feel that given probation, I could complete probation. As you know, I haven't been in trouble before, Your Honor. This is the longest I've been in jail. I feel that I've made a mistake. And if you read the current note I wrote to you, Your Honor, it describes more of my feelings. I want to apologize to the court, and I want to apologize to my wife, who we've been together 11 years, 10 years, been with the family 15 years. All I know is my family, Your Honor. And I'm asking for your leniency and your mercy, Your Honor, for probation classes so I can better myself.
Thank you.
All right, state any questions?
Yes, Your Honor, briefly. Mr. Tovar,
Yes, sir.
in this case, you're charged with a violation of a bond of protective order, as well as a repeat violation of a bond of protective order, in addition to the kidnapping, correct?
I am.
He was.
I was.
And given that there was a no contact order protecting Miss Tovar from you, you violated those no contact orders.
That is wrong. She came to my home and moved in with me because she had no place to live. I wasn't gonna leave my wife and my kids out on the street. So I did not violate it. She came to me and that's how I violated her.
But you were made aware that any contact with Miss Tovar would be a violation of those bond conditions, is that correct?
I was aware, but I was not gonna leave my kids and my wife out on the street, sir.
In this kidnapping case, you did tie up Miss Tovar with duct tape, is that correct?
No, that is incorrect.
And you said you've never been in trouble before, but you did have a case out of Atascosa County, Texas, for a violation of bond or protective order in that county as well, is that correct?
That was for phone calls for talking to my children, which I had the right to do. And if you check the records, it says for electronic communication, I was allowed to talk to my kids.
And you did abscond during that case on February 9th of 2023, is that correct?
Is that,
You just didn't do anything and you failed to report.
I was in jail.
Okay,
It's not that I failed to report, it's just I couldn't go.
okay.
I was in custody. I'm sorry, I said during that incident, I was in custody, so I couldn't go over there.
I have no further questions, Your Honor.
Any further questions? All right, any other witnesses?
No, Your Honor.
All right, the court will hear argument. State, you're opposed.
Yes, Your Honor. We're opposed to the defendant being granted probation. While you heard from the victim that she does not feel protected just by the no contact order, and that the fact that he was charged with a repeat violation of court order bond condition twice, which are being taken into consideration in this offense, Your Honor, shows that the defendant, whatever the allegations were, completely disregarded the court's order, and telling him that he's not supposed to have any contact with the complainant.
But what about his saying that she came to live with him?
But Your Honor, regardless of what the allegations are, if he knew that he had these charges pending.
No, I understand that, but isn't that mitigating the fact that she chose to go and live with him? Now, I understand financially there are issues, but a no contact order, of course, it's a document, it's on paper, and the defendant knows they're not to have contact with them. But what about his saying that he had a choice? Either his children were going to be on the street with her, or either she was going to come to live with him. But it doesn't appear in that situation, if it's truthful, he didn't go and have her come live with him. She decided to go live with him.
That is correct, Your Honor. And while it may be mitigating there, knowing that he did have that no contact order, there are other options for Mr. Tovar to be able to take care of his children without having contact with the complainant. He could have taken the children while Ms. Tovar went to go find another living arrangement.
Do you know she wanted him to take the children and leave without her children?
That I'm not aware of, Your Honor.
Okay.
But given that and given the allegations in this case, Your Honor, we don't feel that we do feel that the defendant is a danger to Ms. Tovar if he were to be granted probation. And so we'd ask that you deny the defendant's application to take it.
All right, defense.
Thank you, Your Honor. As you know from reading the pre-sentence report, my client doesn't have an extensive criminal history. These offenses, although serious, have really made him take a step back to reassess his life and how he lives his life and how he treats his family. And I think he's expressed rather eloquently in the letter that he tendered to the court. He's going to do whatever it takes to fix himself. He's even read the PSI where the recommendations on the tap valve that if granted probation, he should be placed in a program to help make sure he's no longer drinking excessive amounts of alcohol. And he wants to fix himself in that way. And he's been taking some classes in the jail since he's been in jail. It's been a couple of months now to help him control his demeanor, his anger, everything. He's trying to fix himself.
All right, this is what the court is going to do. The court is going to deny your application, find you guilty, sentence you to 9 years in the prison, give you credit for any time served, or you can go off the record. You're going to have to make better decisions in your life.
Yes, Your Honor. This is just a mistake, Your Honor. I wish.
Well, no, it was a choice and it was a bad choice.
Yes, ma'am.
And here's the thing, I understand about protective orders.
Yes.
I understand that sometimes the person who the protective order is supposed to protect, they decide that they're going to go live with the person that there's a protective order against. And then there's an issue that happens and then everybody calls the police and here we are.
Yes.
So
ma'am.
when you have a protective order, you are the person who are responsible. And if somebody wants to come live with you and there's a protective order in place, you need to say no. Do you understand?
I do now, Your Honor.
Well, I mean, you knew beforehand. You just decided, maybe we can work this out. Here's the thing. She doesn't want you anymore. That relationship is over. You can consider her on paper, unless y'all got a divorce, she's still your wife. But in reality, she's not your wife anymore. She does not want to be with you. Do you understand? Do not call her from the jail. Do not call her from the prison. Do not contact her. And if you want to see your children, and Ms. Burke does a lot of civil work, if you want to see your children, then that needs to be done through a third party, but it's not to be done through Ms. Tovar. It's like you don't even know her. Do you understand?
Thank you, Your Honor.
You're welcome.
The witness stated that she observed the defendant to have a small sharp blade in between her knuckles when hitting the complaint.
I want the truth. You can't handle the truth.
Good morning, Ms. Johnson. Ma'am, you were charged with assault, bodily injury. You're facing up to a year in jail and a $4,000 fine. We are going to do probable.
The officer was dispatched to his service in Harris County, Texas. The complainant and the first witness, the complainant's mother, stated that the defendant had been texting and posting on Instagram about wanting to fight the complainant. The complainant and defendant were inside an apartment when the fight began. The witness stated that she observed the defendant to have a small sharp blade in between her knuckles when hitting the complainant. The defendant punched the complainant in the face, causing lacerations and pain. The defendant told the officers that the complainant believed that defendant was with the complainant's ex-boyfriend, which is what started the fight.
And it's just an assault?
Yes, Judge.
Ms. Johnson, I'm going to find that there's probable cause to go forward with the case. I'm shocked that it's not an aggravated assault. Let me tell you, I'm ordering you now as a condition of your bond not to be in possession of any weapons and not to have contact with the complaining witness in this case. Do you understand? Yes or no?
Yes.
I want you to understand that I'm going to do everything in my power to protect the public and every single person in it. And if that means locking you up and putting the bond extremely high, I will do it in a heartbeat. Do you understand?
Yes.
Do you not have contact with this complaining witness? Do you understand, ma'am? No more warnings. You will get no more warnings from us. Mr. McAlpin, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause.
On November 24th, 2024, the officer was dispatched to a residence in Harris County, Texas, in reference to an indecent exposure call. And upon arrival, the officer met with the complainant, who stated that he observed the defendant inside his property without pants and underwear on. The complainant stated that he observed the defendant dry hump the air and roll around on the dirt. The complainant also advised he observed the front driver's side door of his motor vehicle to be open and observed his credit card missing and his in-car charger to be damaged. The defendant was the only person inside of the property at the time of discovery.
Trespass of what?
That was fled, Your Honor.
Is it house? Is it car? Did I miss something?
Your Honor, it just pled as being on the property. It doesn't specify if it was a vehicle, so the complaint just stated that the defendant was inside his property area.
Was there prior notice of him not to be there? Or, because I didn't hear you say anything about prior notice. I didn't hear anything about you saying,
Your Honor, it was just a residence, and in the case of a residence, notice is presumed, and he was.
no, we don't presume anything in the law, you know? I mean, we don't go based on hunches and read it to me again, please.
Yes, Your Honor. On November 24th, 2024, officer was dispatched to a residence in Harris County, Texas, in response to indecent exposure. The complainant stated he observed the defendant inside of his property without pants and underwear on. The complainant stated he observed the defendant dry hump the air and roll around on the dirt. The complainant also advised he observed the front driver's side door of his motor vehicle to be opened and observed the credit card missing and in-car charger to be damaged. The defendant was the only person inside of the property at the time of discovery.
Yeah, I mean, there's no prior notice that he's not supposed to be there. You didn't say anything. You didn't say anything about he's
There's
trying
no
to,
statement as to without permission. The only thing is it is a residential area, Your Honor.
All right, I'm not going to find probable cause to go forward, Mr. McAlpin, but you're on notice now. If you go back to this place, they're going to probably arrest you. Do not go back to this place. Watch out what you're doing. You're on felony deferred for a very serious crime that can give you 10 years in prison. Do you understand?
Yes, sir.
Behave yourself in the free world. And if you cannot, you're going to end up possibly 10 years. You understand?
Yes, sir, Your Honor.
Take a seat.
Thank you.
You are Alex Rojas. Mr. Rojas, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do a probable cause. Okay.
The complainant and the defendant are in a common law marriage, and on August 26, 2024, he also responded to a family disturbance. The complainant and the defendant were in a verbal argument because the defendant accused her of cheating, and the defendant pushed her on the left rib area, causing her to fall and causing pain to her left rib area. The defendant then retrieved a bottle of bleach and sprayed bleach on her several items, causing it to get on her face, shirt, and right arm, causing a painful burning sensation. The defendant then pushed her once more, causing her to hit her head against the door frame, causing pain and a laceration. The defendant then bit the complainant's right arm with his teeth.
Mr. Rojas, I'm going to find that there's probable cause to go forward with your case. A protective order has been issued in this case. I would suggest that you get to know it. If you violate the protective order, it's very possible the state files an additional case against you, a violation of a protective order, and that is the capital murder of misdemeanors. You pick up a VPO, things will go sideways real quick. Do you understand? No contact means no contact in any way, and that's what I'm ordering you now. Don't be in possession of any weapons, and you shouldn't have weapons as it is. Do you understand? Mr. Rojas, heed this warning. Don't have any contact with this person. Do you understand? All right, please.
Yes, sir.
This way.
You need to understand one thing, Mr. Shelby. You don't have anyone that's going to pony up any kind of money to get you out. So when you go to jail, that's where you stay. Do you understand? Yes or no?
Yes, sir, Your Honor.
I am now ordering you to have your ankle monitor over 1% charged. And if it hits a dead battery again, so will your bond. Do you understand?
Yes, sir, Your Honor.
What did I just say?
Keep your charge.
You must charge this thing 1 hour every single day.
Yes, sir.
What did I just say?
Keep it charged every day.
No, that's not what
No,
he said.
not what I said. You have to charge your ankle monitor for 1 hour every single day.
1 hour every single day.
What happens if you don't?
I go to jail.
Amen.
Correct. I will not play this game again. 3 strikes, you're out. And I don't care who is in here arguing on your behalf. I will not play this game with you again.
Yes, sir.
Okay, Lauren.
All right. Mr. Shelby.
And for you, my subscribers that are watching, I have placed upon the screen now a playlist where I release upcoming episodes often, so please save it to your favorites and don't tell the others, as this is for you to say thank you. See you next time.